Alex here with part 21 of the My Docket series on child custody and visitation. I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of this series. Two things that I will glaze over, however, are number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. My ex's parental rights have been terminated. Number two, the nutshell version of the purpose of this series is to prepare one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We left off in part 20 with my ex's attorney's opposition to my motion to modify temporary orders. In part 19, we covered my ex's attorney's opposition to my motion for order to show cause to have her held in contempt of court. This video covers my reply to one of those oppositions, specifically her opposition to being held in contempt of court. Typically, I will go into my mindset between the time of the last video and this video. However, I literally filed my reply to my ex's attorney's opposition on the same day. So I suppose this tells you a whole lot about my mindset. I got a document from the lawyer, prepared a reply, and filed it on the same day. Don't do this. This is not a good idea. This is a way to leave stuff out on accident, inadvertently. I totally understand why I did this. Back then, every day was precious to me. A day felt like a week. Some people may feel like a day feels like a month. And I understand the sense of urgency, the feeling that you have gotten something from your ex's attorney and you need to respond right now. Take advantage of the deadline. You're going to, and this is something that I figured out several years later, you're going to prepare a document and you might be driving around on your way to work, on your way home, out to see some friends, and you will think of stuff. This happened to me all the time. I would think, I need to respond right now and file it right now. And I would, while driving around or even just at work or sitting at home reading a book, I would just think of, oh my God, I should have put this in there. And I'll go and I'll add it to whatever it was that I was preparing to file. And some people will just go and file amendments to the documents. This just creates more work, more confusion. It definitely drives judges nuts. So don't do what I did and don't file a response on the same day unless it's some kind of emergency. And for those people, I would recommend you watch the video Ex Parte Perils, because I talk about how oftentimes what we feel is an emergency, the court is of a different opinion. To us, it needs the response right now, but to the court, it's like, this isn't that big of a deal. We can get back to you in 2 months. And I'm not even joking. 2 months to the court system, at least in Washoe County, is a pretty average amount of time to wait for anything in a child custody case. So I suppose I have said enough with regards to my mindset. That frantic urge to respond immediately speaks to the way I felt about my case back then. It's this all-consuming, this panic, this sense of dread combined with this sense of right now. Everything has to be done right now, immediately. And for most of my viewers who are here representing themselves, you're probably of the same mindset right now. You get a response and you want to figure out what to do right now. A lot of people have that same sense of urgency. And you're going to want to get over that as quickly as you can, because those extra days, taking your time, at least take half the time of the deadline. I mean, I had 10 judicial days, at least take 5. If you want to be, if you want to respond quickly, you don't necessarily have to wait the entire amount of time, but give yourself at least a few days, because you're going to think of things. And not to mention the fact that you're going to want to do a thorough amount of research as to what statutes, court rules, and case law may apply in your particular situation. So let's go ahead at this point and take a look at what I have filed. Here we have my reply to my ex's opposition to have her held in contempt of court. In Nevada, we call them motions for order to show cause. And, well, first off, it looks like I'm using the terminology used in the self-help forum. So if you take a look, the title is Reply to Response to Motion. It should say Reply to Opposition to Motion. I know where I got that phrase from. The self-help forums, at least in Washoe County, refer to this specific type of document as a reply to response, and they refer to an opposition as a response to motion. And maybe they do that because some people who are representing themselves aren't necessarily opposing the motion. They might file a response where they agree to certain things, and so maybe that's just a catch-all word that they are using on the self-help forms in Second Judicial District Court. For all I know, they use these are consistent terminology in Clark County as well, which is a judicial district court. Maybe all across the state they refer to these as responses and accordingly replies to responses. But I just wanted to bring that up before I continued. If you're going to prepare a custom document, use the correct terminology. At this time I didn't know, but later on I do figure that out and I adjust. Comes now petitioner. This is that first paragraph that lets the court know who you are, what you are filing, and what you are replying to. So I identify my ex's opposition to motion. I should have also identified the date that opposition was filed. It just helps the court. So that's one thing to point out. Looks like I'm using a format where I refer to specific paragraphs. You can do this if you really want to, but you don't have to, and in fact it might look a little bit weird. I know that I probably got this from the format used in replies to counterclaims. When you look at pleadings, they are outlined in accordance to paragraphs, and responses to pleadings, for example, the answer to a complaint or to a petition, they follow the same format. They admit or deny specific paragraphs, and the same goes for a reply to counterclaim. So I probably assumed that this was the best way to deal with the opposition. But for all I know, this is how the self-help forms look as well. I just wanted to let you guys know that this isn't really how attorneys do it, at least not my ex's attorneys. She had two different attorneys, and they did not respond to my papers in this manner. But let's continue on. The first reply: I disagree with my ex's claims and would point out that the 9 to 5 schedule was suggested by her during the case management conference, opposed by myself, and not ordered by the judge. So my analysis in my previous videos of the My Docket series was correct. I assumed that this is what I did, but it's nice to read my reply and actually see that I was correct. I did refute the fact that the court, ordered anything on this request that my ex made, and I also did concede that this was discussed at the case management conference. However, it was not ordered. Let's move on. Paragraph 2. I disagree with her claims again. We were not in agreement. She made no effort to ask if a 9 to 5 schedule would be used in the interim, or offer to make up time. Now, that is one of the key points that I made both at the case management conference, prior to the case management conference, and after my ex violated the court's orders. At all three junctures, I told her, if you would like to push this back an hour, I would like to have an hour of extra time. So I am pointing this out in my reply, which is the correct thing to do, because that is going to show the court that there is a basis for which I was, opposing this request. And not only that, but even after my ex violated the court's order, I once again offered her the opportunity to just make it, make it fair and balanced, give me an extra hour, and she refused. So this was, just you have to let the court know these little details, because this is what they look out for. Next paragraph. Let's see. It looks like I disagree again. It is true that the temporary schedule was only to be used for 2 days. I must be talking about 2 visitation days before the new schedule takes effect. And it is true that I can accept a 2-hour variance, but it's not in the best interests that the petitioner comes to the court with this motion for. I'm slightly confused at my wording there. What? The petitioner brings this motion because it is not in the child's best interest. Okay, so apparently my ex's attorney characterized this in a manner that pointed out that I think she referred to me as being like frivolous or something because it was only 2 hours of time that I was losing. And what I am doing here is I'm pointing out to the court that, hey, this is not 2 hours of time that I'm losing with my son. This is 2 hours of time that my son is losing with me. So this is another great argument that I made on reply. And I wonder if I used the shoe on the other foot argument here. I am pointing out the willful and purposeful refusal to appear on time. And I am pointing out the fact that this is going to occur again if the court does not deal with it now, which is absolutely true for the remaining 7 years, because we're now in 2019, of my my high conflict child custody case. My ex does exploit the courts. You could say it's leniency. I think it's laziness. The court's leniency or laziness to deal with this issue immediately. And yeah, this is something that I'm pointing out here. This is something that does happen throughout the case. My ex takes note of the fact that she gets away with this, and she does continue to violate the court's orders. Paragraph 4 warned that petitioner would file. Yeah, I told her what I was going to do if she violated the court's order, and she did it again. So yeah, it's not frivolous when you give the opponent an opportunity to comply with the court's order next time, and then they do it again. And then the next paragraph, okay, so the next line, I do not actually refer to a paragraph. I'm referring to the fact that I filed my request for submission prior to my ex's filing of an opposition, because it appeared to me that she was not going to file an opposition. I'm just letting the court know what I was doing there, no big deal. And I don't recall this becoming an issue at all. I think it was never discussed later on. The court just enters its ruling, and that's it. We move on. I did not request a hearing on this matter because whether by malicious intent of the respondent or a genuine misunderstanding of the previous court order, I believe that it is sufficient according to the exhibits submitted with the original motion that no such modification of the temporary order was ordered. So just basically explaining to the court why I didn't request a hearing. One of the things that I do want to tell my viewers is you can bypass a law and motion hearing, but you cannot bypass an evidentiary hearing on a contempt motion. You have to have an evidentiary hearing if the court is going to hold somebody in contempt. So my logic here, while it might be fair generally in the sense of fairness or logic, it's not consistent with the court rules or the statutes. And this is something that I want to use as an opportunity to direct my viewers to my video, Fairness versus the Law. You shouldn't use, general overarching principles of fairness and logic. You should apply those principles to your research, and ultimately you want to rely upon statutes, rules, and case law. The other thing that I want to mention at this point, because I'm not sure that I mentioned in my analysis of the motion, is that I really should have taken this opportunity to clearly define for the court the two types of contempt that were available to the court, and which specific type this court was going to be needing to apply in its analysis. In this case, I'm not trying to coerce my ex's conduct. I am trying to punish her in order to deter her from doing the same thing in the future. So that would be a criminal contempt that I was seeking, and I should have brought that up to the court in my motion. If not, then at least in my reply. Ideally, it would be in the motion. And I should have also brought up the request for makeup visitation. I'm pretty sure that I discussed that prior, but just in case I haven't, it would have been a good idea to bring that up in the paperwork as well, because sometimes the court just is not going to want to hold somebody in contempt, but they will take that opportunity to give a person, a little bit of makeup time. So again, I may have actually asked for these things and I just can't recall, but to the best of my knowledge, I didn't, and that is one of the things that I wanted to point out to the viewers. So we could go ahead. Oh, I should take this opportunity to direct my viewers to the video Contempt of Court, because I think a lot of my viewers have not seen all of my other videos, and if you don't know what I'm talking about with regards to civil contempt versus criminal contempt, you should definitely watch that video, because those technical details do matter. So I'm going to go ahead now and scroll down. This is my affidavit. It doesn't look like I prepared this custom. Maybe I just took this from one of the self-help. Yeah, it's got fill in the blanks. So I probably took this from the self-help forums and just stuck it to the back of my custom paper. If you're going to prepare a custom paper, you may as well prepare a custom all the way through. Try not to do what I did here. And another thing that I wanted to mention is you don't even need to use an affidavit. That's just going to cost you an extra $5 or $10, and that's going to cost you an extra trip. It's better At this point in Nevada, based on the new statute, I guess you could call it new. It's relatively new, but it's probably been out there for like 8 to 10 years, maybe even 15 years. It's a statute that allows you to prepare a declaration in lieu of an affidavit. And if you do this, you do not need to have a notary, apply their stamp and sign. It is discussed in further detail in my video, Affidavits and Declarations. So definitely take a look at that video. Even if you're not in the state of Nevada, you may find something similar in your state and you may be able to take advantage of that. Affirmation. Again, this is one of the fill-in-the-blank forms. Just lets the clerk of the court know that I am not including the social security number of any person in this document. And the reason that they like this is because they don't have time to sift through all your documentation. They're just going to look for the affirmation and they're just going to take your word for it if you have signed on the dotted line and if you have indicated that the document does not contain a social security number. This is the end of my reply. Let's go ahead and take a look at the request for submission. Once you file your reply, you are ready to request for submission. Now, I have mentioned this before, not all states use this method of letting the court know that you are ready for a ruling. And in fact, in Nevada, not even all counties require this. As far as I know, it is only the 2nd and the 4th judicial district courts. There may be another judicial district out there in the rules that I don't know about, but as far as I know, it is just the 2nd and the 4th judicial districts that require this. In fact, if you are one of my viewers and you are in one of the other judicial districts in Nevada and you also need to file requests for submissions, please let me know down in the comments below so that I can keep that in mind for anytime I have to bring this up again. It comes up quite a bit in the series because I was, litigating in 2nd Judicial District Court, and anytime you have filed all of the documents necessary that require a decision by the court, you have to file one of these requests for submissions or the court is not going to have a clue that something is pending. I talk about this a whole lot more in a video dedicated to this topic, and it is in fact titled Requests for Submission. Please take a look at that video if you haven't seen it yet. I am just letting the court know that my motion, which was filed on January 8th, is ready. It's been fully briefed, and what I mean by that is an opposition was filed and a reply was filed, and the court can now at this point take a look at all 3 documents and render a decision. And that is all. There's nothing else. There's just one page. It's interesting. Usually it has some kind of proof of service or certificate of service, but I guess in this situation it doesn't. Let's take a look at the proof of service. Oh, well, okay. The proof of service is a document that I filed separately, and I'm sure that I lumped the request. Yeah, I did. So the request for submission was lumped into the reply to motion. I am indicating to the court in this proof of service that both of those documents were served upon my ex's attorney. Scrolling down, I apparently personally served this on my ex's attorney, which means that I went to her law office and physically handed the documents to one of the workers at her law office. I have mentioned in previous videos that you do not have to do this, at least not in Nevada. We have a court rule that allows these documents to be mailed to your opponent. When you do this to a law office, it's not as big of a deal as long as you don't make a scene, as long as you're just in and out, drop the documents off and leave. You don't complain to them. You don't try to, denigrate your ex or attack the attorney, because they're going to tell you stop coming back, and they're going to tell you that you are trespassed, and you're going to have to mail stuff from then on. If your ex does not have an attorney and they're representing themselves, I strongly recommend that you do not serve them personally unless you have to. And in this case, this is NRCP 5, we call it Rule 5 service. You can mail this to your opponent, and so if you are in a state that allows this and your opponent does not have an attorney, please mail it to them, because that is one less point of contention. You don't have to see them face to face. You're not going to have to deal with claims that you're stalking them. Here's the declaration, actually, in a self-help form. I was just talking about this. If you take a look at this, you'll see that this provides a mechanism by which you can serve, or not you can serve, by which you can swear under penalty of perjury that you have done something without having to go and get that notary stamp, take that extra trip, that extra drive, pay that extra $5 to $10. It just, the money isn't such a big deal, but it saves time because you're already bouncing around all over the place, from the self-help center to the law library, now to the notary, and then to the clerk's office. It's just one less trip. I remember having to do this pretty vividly. It was like, eventually you get a system down and you get quicker at it, but cutting out that one trip is going to save you quite a bit of time, at least 30 minutes, maybe even an hour, depending on how far you have to drive to get that notary to stamp your documents. So this here is proof, even in the self-help forms, that you can use a declaration in lieu of an affidavit. So I'm going to go ahead and move on. So having gone through my reply, there is one more thing I need to talk about because I didn't put it in my reply and I should have. Now, if anyone here can remember, in part 19 of the My Docket series, my ex's attorney filed an opposition asking for an award of attorney fees. And she characterized that request as a sanction. In other words, she wanted to punish me. She was arguing that my motion to have her held in contempt, her client held in contempt of court, was frivolous and done so with the intent to harass her, and I did not, address that in my reply, and that is not good. Don't ever do that. If your opponent's attorney is requesting an award of attorney fees because they are alleging that you are harassing them, or you are a vexatious person, or that you have filed your papers without any reasonable basis, you need to file an opposition to that, and you need to explain to the court not something along the lines of, oh, well, I disagree that it's unfair for her to have to pay money for a lawyer. None of that nonsense, because you're going to get sucked into that if you stick to the language of the attorney. But using points and authorities, using actual statutes, rules, and case law from your state. In Nevada, up until recently, it was very difficult to get these awards in these disputes. You had to show harassment or that you filed something without a reasonable basis. And the Supreme Court of Nevada and Court of Appeals would reverse awards of attorney fees if you could show that you had some basis for the filing. You didn't even have to show that you won. You could have lost the motion and still win an order reversing. Now there's these new statutes that make it a lot easier for the court to award these fees. There's still ways to fight it, but I'm not going to go into that right now. In fact, I'd rather just direct my viewers to two videos. The first video is Defend Against Attorney Fees. The second video is Attorney Fee Equalizers. But I just wanted to really underline the fact that at this point in time, I had no idea as to the power of statutes, rules, and case law. And I am totally going to kick myself for it and bring it up to my viewers. Do not do what I did. Number one, you need to address those requests. You need to fight that, because if you're in a high conflict child custody case, you're going to be filing a whole lot of papers to protect your children. And the last thing you need is to be paying your opponent's attorney fees when you can't even afford to pay your own. The other thing that I wanted to mention, and I kind of glazed over this a little bit, is oftentimes when the other side doesn't have a good legal basis for the award, they'll use some sort of general are overarching principles of fairness. Usually they will tug on the court's heartstrings about how a client had to pay lawyer fees for something that they shouldn't have had to pay. Don't get sucked into that. Oftentimes you'll end up in this almost philosophical argument about why what they're saying is wrong. Just focus on the law. The law will just totally flatten that argument. And going into the aftermath, I filed all three of these filings and incurred $0 in costs, first of all, because I served it personally. So I didn't even have to pay for a stamp. And second off, because none of them required a filing fee. Replies to oppositions to motion, you don't even have to attach the family court motion opposition notice to it. So just straight out of the gate, it's free, it's always free, and I incurred $0 in costs. My ex didn't file any of the documents mentioned, so she also incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, I imagine, charged her, let's say, 3/4 of an hour for that reply, just to review it, maybe communicate with my ex as to some of the details, for the proof of service, and for the request for submission. We're just going to say 15 minutes for both of those documents. So that's going to come out to 1 hour for my ex to review all three of those filings. And at the rate of $250 an hour, we can assume that my ex paid $250 in attorney fees. As with all my previous videos, post something down in the comments below if you have any questions. You can also find the links down in the description if you want to download the documents for yourself and review them. And if you have any questions that you want to ask me privately, go ahead and email them to admin@theproperperson.com, and I will see you guys next time.